My name's Ruth Bundey. I'm a solicitor and partner at Harrison Bundey, which is part of Ison Harrison. An inquest is held when a death has occurred which is either violent or in some way unnatural. In other words, if a person simply dies of old age or a pre-existing medical condition, there won't need to be an inquest, but where the death is somewhat more unusual, there is one. There will be a coroner for each area or district who will be supported by assistant coroners, and the coroner will hold the inquest and will call the witnesses that he or she feels are needed. There will be a jury in certain circumstances. There will always be a jury where a person has died in the custody of the state. In other words, in a police station or in prison, or if detained under the Mental Health Act, not a voluntary patient. In those kinds of cases where obviously a person is vulnerable because they cannot make decisions themselves about where it's best to be, they are being detained, the state has to answer for what happened, and therefore the coroner will sit with a jury, and what's called Article 2, which is the right to life, will be engaged. The procedure at an inquest is that the coroner decides what should happen, decides upon the witnesses, and questions all of the witnesses first. Then when he or she is finished, it's up to the other representatives who are there, representing perhaps the police or the health authority or the family, to ask supplementary questions that they feel will help with the conclusions. There can be funding available. It's a bit of a dodgy area, and many people have said, including people who've done reports on the whole system, that funding for families should be non-means tested and should be automatic, just as the other interested parties at an inquest will be funded by their own organisations. That hasn't come into force yet, so the answer is that, as I say, it's a bit of a grey area, but there may be exceptional funding available. Sometimes there's simply a short form conclusion at an inquest, such as accidental death. In the more elaborate inquests where the right to life is involved and somebody, say, has been detained, a jury will be encouraged to bring back what's called a narrative conclusion, which is like, in a sense, a small sort of essay detailing what they find to be the central issues in the case, whether there have been any systemic failings or missed opportunities in general terms. What an inquest can't do is name individuals or apportion blame or anything like that, in the sense that the criminal courts and civil courts can do that. There won't be anybody named at the end of an inquest as having failed, but it might be that a system is referred to as having been lacking. If you need further information about inquests, please look at our website or feel free to phone us on 0113 284 5000 and ask to speak to one of us